Okay, this is the Supreme Court of the United States ruling in Louisiana versus Callais. I think you can go online and figure out what this is about pretty easily, and there's probably all sorts of YouTube channels and blog posts saying that they're gutting the Voting Rights Act, and so on and so on. So I'm not going to go too deeply into the background, but I do want to go over some of the sentences in the majority ruling here. I think that the dissent is pretty clear and obvious. The dissent basically says, look, this allows for racist congressional districts to be drawn, for racist laws to be used, as long as they don't straight up say it's racist. And the entire history of the Voting Rights Act is specifically and exactly to attack and stop racial activity, anti-black activity by the powers that be of the southern states, by saying that the ruling must be that if it has a racial effect, it can't go into place, versus if it has a racial reasoning, right? So if some big muckety-muck in the state capitol says, well, I'm going to pass this law, or I'm going to create this district, and I'm doing it because I don't want black people to vote, then that's illegal. If he says he's doing it because he doesn't want Republicans to vote, or he doesn't want Democrats to vote, or he doesn't want Green Party people to vote, or he doesn't want environmentalists to vote, that's totally fine. If those people happen to be black, well, that's just accidental. And this is an obvious weak point. The majority here has a different view of this historically, I think. That is the history of the place that we are living in now, and we'll get into that. But I think that's part of the main issue at point here is the dissent is saying, look, we've got a bunch of history saying that racial crap is going to start, and this is exactly what we're going to see in the Voting Rights Act was made to stop this, and you're just overthrowing it. And the majority is basically saying, look, racism isn't real. But we'll get into that. Okay, so this is interesting, right? One problem resulted from the rule that in racial gerrymandering cases, unlike other cases involving claims of racial discrimination, strict scrutiny is triggered only if race predominated in the state's decision-making process. Another problem stemmed from the long unresolved question whether compliance with the Voting Rights Act provided a compelling reason to be justifying the intentional use of race in drawing legislative districts. For over 30 years, the court has simply assumed, for the sake of argument, the answer is yes. Okay, so basically, the majority is saying, well, a problem with the Voting Rights Act is we never actually answered the question whether the law says that you have to take race into account when drawing districts. In fact, the court for the last 30 years, the precedent of the court for the last 30 years is that the Voting Rights Act says you must take race into account when looking at districting, right? You must look at the districts and look at the laws and the rules regarding voting and say, does this affect people who are black? Does this affect people who are white? Because they are black or white. If you look at them as a group, is this group strangely, for whatever reason they may say this new law is being passed, but is this group affected in a negative fashion, particularly? And that seems kind of strange, right? I mean, you may say, well, I don't like environmentalists. Well, okay, so if you don't like environmentalists, that's fine. But if the environmentalists tend to be poor or because they suffer from environmental issues, and if you're black, you're more likely to be poor, so by getting rid of environmentalists, you're more likely to get rid of black folk in your area. And you say you're not going after black folk, but you seem to be, like, the effect is that you actually are. And what's going on here, right? This is a question to ask. Like, you may say you're doing this for whatever reason, but that doesn't ring true, right? I'm very suspicious about that. Or well, you passing this law, well, it has unintended consequences which disenfranchise, all these black or all these white folk from having their say. And the court has simply assumed that, hey, you got to look at that. You got to think about that. You got to take that into consideration. You can't just say, well, we're not going to look at whether people are black or white. That doesn't matter at all in any way whatsoever. And we're just going to look at the environmentalist factors, or the Republicans and the Democrats, or the urban and the rural, or whatever, right? But we don't even need to look at whether they're black or white. We don't need to care about whether they're black or white, right? And the Voting Rights Act has said, the court has held for the last 30 years that, yeah, you do. You have to look at these racial groupings because of the history of your states, because of the history of the country, and so on. And the court, for 30 years, has simply assumed for the sake of argument the answer is yes. Basically, what this is written by Alito, I think. Basically, what this is saying is, look, this power of the Voting Rights Act was so incredibly obvious to every court before us that they didn't even need to mention it. But since they didn't specifically say, now we can look at it, because it's not obvious to us. This is like arguing over the definition of the word I, the definition of the word yes, or the definition of the word definition. It's like, you seriously have to get into this? Like, what the ruling is saying right here is that there is a precedent that existed for how the Voting Rights Act has been interpreted. But that precedent does not exist because this court never ruled on it. Therefore, we are overthrowing the Voting Rights Act, but we were not actually overthrowing it because there was no precedent to hold this, to uphold this, which is a whole bit of doublespeak right there, right? Well, we are not overthrowing precedent, even though right here you admit that the court has assumed that this is the precedent. Right? The court has acted as if this is the precedent. The court has ruled as if this is the precedent. Therefore, it is the precedent. Right? It's the bedrock underlying the court's decision upon this law. Right? And then it is held by the majority here. The Voting Rights Act did not require Louisiana to create an additional majority minority district. No compelling interest justified the state's use of race in creating the district, and that map is an unconstitutional racial gerrymanderer. Basically, look, the VRA did not allow you to look at race when making districts. And since you did look at race in making districts, these districts are illegal. Okay, so there's some bits here, right? The Constitution almost never permits a state to discriminate on the basis of race, and such discrimination triggers strict scrutiny. The court's precedents have identified only two compelling interests that can satisfy strict scrutiny, avoiding imminent and serious risks to human safety in prisons, and remediating specific identified instances of past discrimination that violated the Constitution or a statute. Okay, basically, the ruling is saying here, look, the state cannot discriminate on race. The state cannot look at race. The state cannot pass laws which affect one race more than another, which, of course, ends up being a problem, right? How do you know whether your ruling, whether your laws, whether your districts affect one race more than another if you are not allowed to look at race or consider race? Right? It's like this is the ruling here actually does is it says racism does not exist. Right? The precedents have identified two compelling interests that can satisfy strict scrutiny, avoiding imminent and serious risks to human safety in prison. Basically, look, it turns out when you get a bunch of people of the same gender and throw them all together in a tiny box, they tend to act as if race exists. I mean, that's kind of strange, but if we pretend that race didn't exist in that case, we'd have a lot of people killing each other and hurting each other. So we're going to pretend that race exists there. Among those people in prisons who are locked up and are supposed to be dangerous. I mean, in many cases are dangerous, but it's interesting, right? when it comes to actual physical violence, all of a sudden race isn't something to look at. Right? This is something we saw in the civil rights era, right? Racism is ignored. It's totally fine. You have your side of the town, we have our side of the town. You can't come here, blah, 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 blah. But what overthrows it? Well, it turns out people showing up in force. It turns out people involving themselves in marches and folk just boycotting certain businesses or folk showing up. That is, all of a sudden, now that physical violence and bodily autonomy is involved, race matters again. But until then, you just sweep it under the rug. And that's exactly what is happening here. And then the second one, the second compelling interests. Remediating specific identified instances of past discrimination that violated the Constitution or a statute. Basically, it's saying, look, if you can prove that something in the past was racist and that affected people today, then you can pass laws which will strike that, which will take the racial activity in that case into consideration, or you can strike down laws which you can show are clearly racist. This means that if you can show something's racist, you can strike it down. But it must be a specific identified instance of past discrimination. It can't be something general like structural racism. It can't be that, well, black people tend to vote Democrat or Republican, and we're attacking Democrats or Republicans. It can't be that black folk tend to be more urban, because you're just targeting urban folk. No, it has to be because you were targeting black folk specifically. Or white folk specifically, in this case. Or yellow folk, or green folk, or gray folk, or red folk, or, I don't know, pick a color, pick a group. Y folk or X folk, blah, blah, blah. Basically, the question that arises, well, how do you remediate specific identified instances of past discriminations? You have to identify the instance, and it has to be specific. You just say, this law at this point did this effect, and we're going to undo that law. Or this effect, it happens at one specific point, and it affected this racial group, so we're going to change the law. And it must be identified in instances. It must be something where a court has said, this is racist. So the question, of course, immediately arises, how does the court determine whether something is racist? Well, what this ruling is going to say is that you must have caught somebody on tape or in writing saying that they are doing this because they don't like the black folk or the white folk. They are doing this because they don't like this racial group. If they say that they are attacking, that they don't like urban folk, or they don't like people who like hip hop, or they think that rap is a dangerous music which corrupts the youth, or they think that, I don't know, use of sunscreen needs to be mandated because it protects against skin cancer. I don't know how that would be racist, but it's just an idea. You can come up, I'm sure you can come up with something. You're like, well, we're going to discriminate on the basis of skin color here regarding sunscreen, and like how it's sold or how it's marketed. Or like, you can't say in your marketing that this sunscreen is better for dark skin, or this sunscreen also moisturizes ashy skin, because that would be looking at race, and you can't do that, or something like that. Okay. Okay, let's continue. I don't know what I'm getting into here. It's a very emotional thing to read, right? It's a very emotional thing to think about. And given that race and racism and discussions about them tend to pervade all our activity in the United States, it gets a little messy. Okay. Under Section 2A, the court takes as a given that a legislative district map may constitute a town. Oh, this one is also interesting. The key concept is less opportunity than other members of the electorate, which sets a baseline against which to assess the opportunity of minority voters. That baseline, the opportunity that any given group of voters has to elect their candidate of choice, depends on the voting preferences of the other voters in the district. For example, in a district where most voters vote for Democratic candidates, a Republican voter in that district will have a low chance of securing the election from his or her preferred candidates. Thus, the opportunity of these members of the electorate to contribute their voices to a winning cause is whenever opportunity results from the application of the state's combination of permissible districting criteria. That is, where a randomly selected individual voter and group of voters can expect regarding their opportunity to elect their preferred candidate. Under number 2 here, section 2, a minority voter is entitled to nothing less and nothing more. Basically, what this says, as I understand it, is that if you are a minority, you do not get proportional representation. You may be, as a group, whatever the group may be, 40% of the people in a district. You do not get 40% of the political power. You do not get 40% of the vote. This is a majority rule, straight up, flat out, 100%. Right? A minority voter is entitled to nothing less and nothing more than the opportunity to express their views. And that baseline, to the ability to express your view, depends on the voting preferences of other voters in the district. So, if 51% of the people in the state have elected somebody, then their vote is all that counts. The other 49% doesn't matter, doesn't count. It is not at all important here, because your baseline, whether your voice counts, depends upon the voting activity of the other people in the district. Now, since the people in charge of your state government can decide which districts are which, how they're shaped, who gets in there, that means that they can split up a group. And so if you split up all the Democrats in the state, or all the Republicans in the state, such that they only constitute 40% of any district, then even though 40% of the population is Democrat or Republican or black or white or gay or straight, they don't matter. They don't count. Because they have the same baseline opportunity to express their views as everybody else in the district. And we have a majority rule. It's just basically saying you don't get proportional representation. 40% of the people does not mean 40% of political power. It means 40% of the voices raised. But if you can't convince the other 51%, then you don't get anything. You get zero. You get zilch. Now, this does matter. This affects the other side too, right? All the white folk, like this is one of the bits, right? Okay, so let's say you have a majority black district. Well, then that means that all the white folk in there don't get their voices heard. Oh, that's interesting, right? Because that only matters if black folk and white folk vote differently. That is, this only matters if you have different racial activities. This only matters if you pass racist laws. And so if racism exists, then this is something to look at. If racism doesn't exist, then then this doesn't matter, because it's not about black and white folk, it's about liberals or conservatives or whatever the case may be. So we're starting to see something, right? This ruling is really actually about, does racism exist or not? Is the Louisiana state government, on a whole, the people who decide these districts, are they racist or not? And the majority here has said, no, they are not racist. And therefore, this baseline idea comes in. Now, if they are racist, then all of a sudden this baseline looks a little iffy, because who are the members of the group that are being looked at? What I'm saying here is, well, you're looking at the members of the group in the district. Well, what about the members of the group on a state level? That's looking at it differently, right? It's basically, yeah, if racism doesn't exist, if black folk and white folk vote exactly the same along those racial lines, then the redistricting doesn't really matter. But if they vote differently, then the redistricting does matter. Okay. Okay, so they interpret the 15th Amendment confers on Congress the power to enforce the amendment by appropriate legislation. Right. So this court's saying, yeah, the 15th Amendment says you can pass the VRA. And then he goes in here, right? Properly understood, Section 2 does not intrude on states' prerogative to draw districts based on non-racial factors, including to achieve partisan advantage. In short, 2 imposes liability only when the evidence supports a strong inference the state intentionally drew its districts to afford minority voters less opportunity because of their race. Right? So this is exactly what I was going on before, right? If it just so happens that we're giving the Democrats or we're giving the urban voters less of a voice, that's totally fine. We can't give the black voters less of a voice, but if your black folk are more likely to be urban or Democratic, that's just accidental. And the VRA was specifically designed to stop this, to say, no, you can't just disenfranchise all the black folk because they happen to vote in ways you don't like. And this court is saying, well, you can disenfranchise folk based on the fact that they vote ways you don't like. I think this was absolutely incredibly wrongly decided. It is obviously nothing more than the ability of entrenched interests to remain in power. It is not merely a political question. It is a intensely democratic question. Can the person who is voted to have power decide who votes him in, or who votes her in, who votes them in? And I would say no. No, this goes against the very basis of democracy. It is saying that instead of people electing the representatives are electing their people. It's totally backwards. It is the doom of democracy to continue in this direction, but this court seems to enjoy this outlook. I think they've totally gotten backwards how democracy works. They simply, it's an attempt to destroy the United States. It's an attempt to destroy the spirit of the United States. It's the old history of nobles and whatnot rising up, where they can say, well, you get out, you get out, you get out. In this case, they're saying, well, you can come in, you can come in, you can come in, you can vote for me, you can vote for me, you can vote for me, but y'all over there, they won't vote for me, so they're out. They can go someplace else. They can vote for somebody else. They don't matter because I can keep them at 40% and 51% wins. Oh, here we go. Something interesting, right? To satisfy the second and third preconditions, the plaintiffs must provide an analysis that controls their party affiliation, showing that voters engage in racial bloc voting that cannot be explained by partisan affiliation. Basically, if you're black, if the black folk tend to vote Democratic and the white folk tend to vote Republican, then racism doesn't exist. The race doesn't matter because they're going to vote Republican or Democrat. And so you're not actually striking at the black folk with the white folk, you're striking at the Democrats or Republicans. If they happen to be black or white, that's totally accidental, is what this ruling is saying. And again, this is obviously problematic. It is giving evidence, or it is suggesting that evidence is not evidence. If the black folk in an area tend to vote Republican, or tend to vote Democrat, or tend to vote Green Party, then this shows that they are voting as a racial bloc. This shows that they are voting as a racial group. this shows that they show the fact that they have a preference for one party over another shows they are voting as one racial group. You can't say, well, they're voting as a racial group, but they're not actually voting as a racial group. What is this? Well, they just happen to all vote Democrat. Or they tend to vote, the black folk tend to vote Democrat. And so we're going to stop all the Democrats from voting. Well, then you are effectively, actually stopping all the black folk from voting. That's what you were actually doing, right? And all this shade about, well, what it has to be outside party affiliation is crap, is absolute utter crap, because the effect is exactly the same. You can say Democrat or Republican, you can say black or white, and you're going to have the same exact effect, right? You would have to show, for this to hold water, right? For this idea to hold water, you would have to show that, like, if you're black, there is no tendency to vote Democrat or Republican whatsoever. And this precludes, like, this, what this is saying is that if racism doesn't exist, if race doesn't exist, right? If people do not tend, if people who are all black do not tend to act as one group or be treated as one group, because if they all act as one group, well, then you have a racial preference. If they're all treated as one group, this is going to result in them acting as one group, right? If you are constantly pushing up on the rural population, they're going to tend to act in one way. If you constantly attack the urban population, they're going to tend to act in one way. And if you have racial groupings of black folk here and white folk here, and more tendencies, so on, you can tend to act in one way. And so one of the problems with something like this, which can arise, of course, is that almost certainly, in today's America, you can look at any group whatsoever and say, well, there is a racial preference. You know, black folk or white folk or red folk or yellow folk or people between the ages of 16 to 32, or males that have never had a date between the ages of 7 and 17, or retirees that own their house tend to vote in a certain way. Well, yeah, because they have interests that align. In the same sense, you're going to have black folk are going to tend to vote in a certain way because they have interests that align, because they tend to live in the same areas, they have experienced the same general racist effects, because there is communication and artwork that exists within the community which affects how they think and act and speak. Again, this is just, it's incredibly common sense. And this number 2 here, this section 2 here is ridiculous. It says that evidence is not evidence. Just to reiterate, it says that if they tend to vote as a racial group, and they tend to vote Democrat or Republican, well, then they do not vote as a racial group. It's ridiculous. Okay, and then here on number 3, on the totality of circumstances inquiry, the focus must be on evidence that is more than a remote bearing what the 15th Amendment prohibits. Present-day intentional racial discrimination regarding voting. Discrimination that occurred some time ago, and present-day disparities characterized as ongoing effects of societal discrimination are entitled to much less weight. Look, what this is saying, what the majority is saying here, is that, look, racism happened, we acknowledged, but the fact is, that's done, that's over with. Just because there was racism here 5 years ago, or 10 years ago, or 20 years ago, or 30 years ago, doesn't mean there's racism here today. This is, of course, incredibly suspect, but you get more into the understanding of what's going on here. The majority ruling here is saying racism does not exist. They're saying there was racism, but we're not concerned about that. We're not concerned about the effects of racism. We're not concerned that black folk will tend to vote in a certain way, or tend to be more urban, and therefore tend to vote in a certain way, tend to vote as a racial bloc, because that is due to effects of something that happened many years ago. Therefore, it doesn't matter. Like, You have to show that racism is going on today, is what they're saying. You can't show that racism happened back way when, except, of course, the problem being that racism didn't happen way back when. What was it? Racism happened in the 50s, the 60s? Those people are still alive, right? I would expect racism to disappear at the minimum, 200 years after the Civil Rights era. Why? Because all the people who were involved in the Civil Rights era, who were so adamant that black folk and white folk couldn't be like this or had to be like that or so on, whatever the case may be, right? They're all dead. And all their children are dead too in 200 years. But the plain fact of the matter is, a huge number of people who were absolutely, completely, clearly racist in the 40s and the 50s and the 60s and the 70s are still alive today and voting. This is not the past. This is ongoing. And this bit here in number 3 is a total... What's the word here? Oh God, it's not a lie. It's not a ghost or like gaslight. It's total gaslighting. Essentially, it's saying, look, racism happened, but that's over and done with. We beat it. We beat racism, and this is obviously problematic. Yeah, Alito delivered the opinion of the court, which Roberts, Thomas, Gorsuch, Kavanaugh, and Barrett joined. Thomas filed the concurring opinion, which Gorsuch joined. Kagan filed the dissenting opinion, which Sotomayor and Jackson joined. So Alito was writing this. And it evidences some of the problems with Alito's thought here. In that it flat out contradicts itself. And now we get to the full opinion of the court, written by Alito. Another problem stems from the long unresolved question whether compliance with the VRA provides a compelling reason that may justify the intentional use of race in drawing legislative districts. For over 30 years, we've assumed, for the sake of argument, that the answer is yes. Then you assume. So this is a clear precedent. It says, allowing race to play any part in government decision represents a departure from the constitutional rule that applies in almost every other context. Yeah. These and other problems convince us that the time had come to resolve the compliance with the VRA can indeed provide a compelling reason for race-based redistricting. Okay, so this is problematic right here, right? These and other problems convince us that the time had come. He does not name any problems. Under our existing case law, that situation posed the question whether race or politics was the state predominant motivation. Yes, this has been the case even way back when. Like the VRA, the Voting Rights Act, is specifically designed by Congress to say we're going to look at the racial effects. When the race and politics was the state preeminent motivation. The VRA says motivation does not matter. The situation posed the question whether race or politics was the state predominant motivation. That question is not posed. That question is not a problem. That question does not apply. The VRA says that the racial effects matter, not racial motivation or non-racial motivation. Right? So this is not a problem. This is a problem which does not exist. According to the VRA is not concerned with this. The VRA does not ask this in any way whatsoever. This is not an actual problem. Another bit here, from the long unresolved question whether compliance with the VRA provides a compelling reason. For over 30 years, we've assumed, that for the sake of argument, the answer is yes. So again, this is not a problem. This is settled precedent, right? assume for the sake of argument, the answer is yes. This is not an issue. The VRA answered the first problem by saying we're not looking at that. This is not a question which the VRA concerns itself with. Okay, and for 30 years we've assumed for the sake of argument the answer is yes. The VRA can provide a compelling reason that may justify the intentional use of race in drawing legislative districts, and you've assumed that it can. So again, these aren't problems. These are decisions by the court. These are decisions by Congress that have already been made. When Alito says they're a problem, he does not mean that they are causing an issue in activity. He does not mean that there is a philosophical question at play here. He does not mean that there is a legal question at play here. What he actually means is that he does not agree with the VRA. He does not agree with the political reasoning of the VRA's constructors. He does not agree that motivation shouldn't matter. For Alito, racism is only I don't like black folk, or I don't like white folk, or I don't like Indians, or I don't like Chinese, or whatever the case may be. It is that and only that. If you happen to say want to lock up a bunch of Japanese people in a camp because you're at war with Japan, and the Japanese people are more likely to be sympathetic to the Japanese empire, well, then that's not racist, because you aren't saying I don't like the Japanese. You're saying the Japanese are a potential problem, and then we're going to throw them in the camps. But the effect, of course, is you taking all the Japanese people and throwing them in Korematsu. No, what was it? No, that was the ruling. Korematsu was the ruling. I don't remember the name of any of the camps off the top of my head. And this is obviously problematic. I mean, I can say I don't like rap, and I don't like do-rags, and I don't like urban decay, and I don't like people playing loud music, and I don't like poor folk, and I don't like people who have curly hair. And you add all of those together, and well, you're describing my black neighbor down the street. And I go, no, I'm not talking about them. I'm talking about someone who just looks like them and acts like them and presents themselves in all ways whatsoever like them, but not because they're black. It's all the things that come from them being black, but not because they're black. It's okay, this is racism disguised. So yeah, you see that Alito here has an entirely different view of racism. Racism is straight up, I don't like black folk, and that's it. Nothing else is racism. And then he goes into some history, right? The 15th Amendment provides the right of citizens in the United States to vote shall not be denied or abridged on account of race, color, or previous condition of servitude. For many years afterward, however, states heavily suppressed the right of black citizens to vote. The 15th Amendment authorizes Congress to enact appropriate legislation to enforce the amendment's protections. And in 1965, Congress invoked that power to enact the Voting Rights Act. And Mobile versus Bolden, the court interpreted this language, and four justices concluded, plenary opinion, that factually neutral voting practices violate to only if motivated by a discriminatory purpose. And then here, Justice Stevens, blah, 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 blah. Critics argue that a focus on discriminatory intent rather than discriminatory effects would declare worthy claims because of the difficulty proving intentional discrimination. Duh. Okay. Basically, Congress, we passed the 15th Amendment, said you have to allow black people to vote. And the bunch of the southern states said, the hell we do. We're going to stop that from happening. And we're going to pass laws which affect black folk, but we're not going to say we're affecting black folk. We're going to say we're affecting, like urban folk who live in cities and vote Democrat. And are poor and listen to this weird new music. It's like, what? It's ridiculous. It's a mask. And so in 1982, Congress sought to abrogate the decision by amending Section 2 an effects test. So on and so on. Okay, so there's a history. The court has found that states have acted discriminatorily towards race in previous moments. White presented a situation in which circumstantial evidence suggested very strongly that the state created multi-member districts for the purpose of diluting minority votes. Okay. To succeed in proving a Section 2 violation, a plaintiff must make 4 showings. The plaintiff must show that the minority group in question is sufficiently large and geographically compact to constitute a majority in a reasonably configured district. The minority group must be able to show it is politically cohesive. The minority must be able to demonstrate the white majority vote sufficiently as a bloc to enable it to defeat the minority's preferred candidate. A plaintiff who demonstrates the three preconditions must also show the political process is not equally open to minority voters. Basically, what constitutes a minority, a racial minority? Well, you have to, jingles here. A ruling by the Supreme Court says you have to be in one area. That is so that you can act as a geographically distinct group. You have to be politically cohesive. That is, it must be the case that all the folk of this racial group tend to vote in a certain way. You must be able to demonstrate that the majority vote sufficiently as a bloc to enable it to defeat the minority's preferred candidate. And that is, you have to show that that someone can break up the districts in such a way that the minority's vote doesn't matter. And the plaintiff who demonstrates 3 preconditions must also show, based on the totality of circumstances, that the political process is not equally open to minority voters. Basically, look, we can't have, we basically, look, we're a bunch of black folk. We tend to be in a certain area. We tend to vote in a certain way. We are not a majority. That is, it is possible to disenfranchise us because we don't constitute 70% of the population or whatever is mathematically necessary for discrimination not to be possible here. And you have to show that, hey, there is not a long history of black politicians or politicians who cater to the black vote in this redistricting decision. It's a bunch of people who we haven't been able to elect. We don't have our voice on the board. Here, yet we never decided whether compliance with the Act can constitute a compelling interest. Instead, we repeatedly assumed without deciding that the Voting Rights Act can constitute compelling interest, because in all those cases, the Act actually did not demand the state's race-predominated districting. Look, he's saying that, look, the court assumed the Voting Rights Act could do this because the Voting Rights Act actually didn't do this in any case. I'm sorry, what? We assumed the VRA could act as a compelling interest because it never actually acted as a compelling interest in any of those cases. Well, then you didn't assume it then. Right? This flat out is not quite contradictory, but this is incredibly confusing. Like, how did you assume that it could do this if in no case it actually did do this? In no case it actually was a compelling interest. Well, then you didn't assume it. Or you did assume it, and that led to some other ruling being made based on that assumption. Therefore, you did decide it. Therefore, it does compel. So either it compels or it doesn't compel. Either you decided that it didn't compel or you decided that it did compel as a precedent. And he's saying here that we didn't decide that it compelled as a precedent, and it never did compel as a precedent. Well, then why are you saying that you decided that that you assumed it could constitute a compelling interest? If he said here, we did not assume that the VRA could constitute compelling interest because the VRA, in all the cases that we decided, did not compel, then that would make sense. Right? If he said that we assumed the VRA could constitute a compelling interest, and it did compel in those cases, or that assumption led to an action in those cases, then that would make sense. But we assumed that it could compel, but it never actually did compel. Why would you? That doesn't make a lot of sense here. Like something is missing here. Why would the court assume, but that assumption doesn't matter? So what he's trying to say here is, I'm not overthrowing precedent. Alito was saying, I am not overthrowing precedent because we never actually decided this. We just assumed it. How do you know that you assumed it? Is my question. The only way to know that you assumed that the VRA compelled is for that power to have affected a decision. Therefore, it is a precedent. And he's saying, no, we never actually did that. It's a precedent, but not a real precedent. I'm like, that's a lie. It's a precedent or it is not a precedent. You can't claim it's a precedent, but not a real one. You're just running around in circles. And he comes up with a bunch of definitions and arguments here. But yeah, it was assumed, but it was after assuming for the purpose of resolving the suit, the compliance could be a compelling interest. We held the plan failed strict scrutiny. If you would need to assume that compliance with Section 2 of the VRA could be a compelling interest for the purposes of resolving the suit, then by resolving the suit, it creates the precedent that Section 2 of the VRA creates a compelling interest. Otherwise, you would not needed to have assumed that compliance with Section 2 could create a compelling interest in order to resolve the case. So it is a precedent, according to his own arguments here. Okay. According to his own arguments, it either is a precedent or it is not a precedent. But he is saying that it is a precedent that never actually applied. He's saying it's a fake precedent. But that is not what his own arguments are saying here. It's my way of understanding this. yeah, then the history, blah blah blah. You know, cracking the black vote, which happens to be the urban vote, which is a whole other issue. In so diluting the effects and so on and so on. And they show a bunch of maps. And then then a court decided that and then he goes into what the Voting Rights Act actually says. You know, to answer the question of whether the VRA compels with respect to the drawing of legislative districts, we turn to the text of that provision. Okay, and the text of the provision, section 2 of the VRA. No voting qualification or prerequisite to voting or standard, practice, or procedure shall be imposed or implied by any state or political subdivision to a manner which results in a denial or abridgment of the right of any citizen of the United States to vote on account of race or color as provided in subsection B. And B, a violation of subsection A is established if, based on the totality of circumstances, it is shown that the political processes leading to nomination or election in the state or political subdivision are not equally open to participation by members of a class of citizens protected by subsection A. That its members have less opportunity than other members of the electorate to participate in the political process and to elect representatives of their choice. The extent to which members of the protected class have been elected to office in the state political subdivision in one circumstance which may be considered, provided that nothing in this section establishes the right to have members of a protected class elected in numbers equal to the proportion in the population. Okay, so this is just my reading of this. Okay, and we'll go into his after this, but for mine reading of section 2 of the VRA. Right, basically section A. No voting qualification or prerequisite to voting, standard practice or procedures to be imposed. Color. Basically, section A says that you can't require a qualification to vote or a prerequisite to vote, or you can't have some sort of practice or procedure related to voting which denies the right of someone to vote based on their race or color. You can't have a rule or a law or an effect or a practice which says this black person cannot vote. So what that says is that, look, as long as they can cast a vote, it's fine. Then you get into the section B, though, which is where I think the VRA actually stands up. In this case, a violation of subsection A is established if, based on totality of circumstances, it is shown that political processes leading to nomination or election in the state or political subdivision are not equally open to participation by members of a class of citizens protected by subsection A, and that its members have less opportunity than other members of the electorate to participate in the political processes and to elect representatives of their choice. Okay, and it's provided that they're not elected in proportion to their population. So basically, it says, look, you may have 40. The black people may be 40% of the population, but that doesn't mean they get 40% of the political power in the state. Right? This doesn't mean that they get elected 40% of the representatives just because they're black, or just because they're white or gray or cows or sheep or wolves or whatever. But are not equally open to participation by members of a class of citizens protected by subsection A. So, if you have a bunch of black folk and they are split in such a way that they, as a contiguous racially distinct group that acts that votes in a racially distinct manner, cannot elect one of their own to affect how these districts are split up, then this is a clear violation of VRA to me. It's not just well, you're black, so you can't vote. It's this group of people are unable to affect the political process that controls the amount of their representation. And so you aren't just looking at the issue right now, is this group cracked? You are also looking at historically, and what this really means is not only do we have to ask the question, are the black folk being cracked out of political power now, but have they been cracked out of political power in the past? And really this comes down to, well, how do we know whether they're being cracked out of political power? You have to look at whether being black means that you vote in a specific way, or that you're more likely to vote in a specific way. If you are, then this suggests incredibly strongly, the totality of circumstances, this suggests incredibly strongly that racial factors are at play. So this goes back to an old idea I have, right? In order to overcome racism, you have to get rid of race entirely, or at least effectively get rid of it in these political processes, right? You need to create it. You have to create such a world that the fact that you're black or white does not control for your political activity or how you vote. But until that day happens, racism still exists, right? So part of the problem comes saying, look, you could probably find some other group. You could say like, well, look, 40% of the population in this county are urban and 60% are rural. And the urban people are consistently losing votes. Well, yeah, that's discrimination against the urban people, yeah. And yet that seems totally fine, right? Well, it's 60% of the people in the 60% of the population keeps voting, and just because 40% are rural, hey, they don't get equal representation. They get 0% of the vote. They don't matter, and that's perfectly legal. But if you say, well, it turns out that 90% of the urban folk are black, then all of a sudden it becomes an issue. But why is that? Why does that become an issue? Here, at least, because of the 15th Amendment, right? It says, the 15th Amendment says nothing about, well, you can't discriminate against urban voters, but it does say you can't discriminate against voters by race. And so pretending that all the urban folk are not black is just confusing. It just is drawing a veil of disinformation over this. Yeah. And if you can, again, so this goes back to, what is it, Gibbons or Gifts or whatever it was, right? You may have 40% of the people in the state be black or white, but if they're equally distributed throughout the entire population, then you can crack the districts every way you want. You can have an equal distribution, and the black voters kind of account for equally as much in every area. But if you have them in a specific contiguous area, it becomes a little more complicated, right? Because not only are you disenfranchising all the black folk here, but you are saying that these folk who tend to be in a specific contiguous area, tend to vote as a specific group, are being broken up. And anyone looking from the outside is going, wait, you mean like the entire city of Memphis or whatever doesn't elect anyone to state office? I don't know what countries, what cities are in Louisiana. Well, that seems a little interesting. And it goes on, and I can go on. But look at even the way I'm talking about this. It seems a little interesting, right? Because how do I prove it's racism? How do I prove it's racist if you just happen to be splitting up the urban vote or the Democratic vote? But you have to admit racism exists. You have to say, well, look, these black folk or these white folk or these dogs and cats form a rather contiguous group. And now you get into the problem of having an opinion.